Good morning, and thank you for joining us. My name is Kelly Weiner, and I'm a partner at Scott Legal PC. And today we're going to spend some time talking about how to obtain a green card based on company sponsorship. A few housekeeping items before we get started. Some of you may know our law firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the US on an E-2 visa and has been on several different visas, including F, TN, B, and H-1B. As such, we know what you're going through. The firm is a full-service immigration law firm and offers immigration services in a number of different areas, including E1, E2, TN, L1, family immigration, national interest waivers, EB-5, extraordinary ability visas, PERM sponsorship, also called company sponsorship, and more. At the end of this webinar, we will send out several useful tools. One will be the PowerPoint presentation we're going to go through today, also a link to where you can download guides that go through visa options in more detail, a link to where you can sign up for additional webinars. And this webinar is being recorded and will be made available on YouTube, and we will send you the link for that. We encourage you to subscribe to our YouTube channel and hit the notification button as we regularly post immigration videos on a wide variety of topics. We will also send you a link to where you could sign up for consultations. So as I mentioned, my name is Kelly Weiner, and I'm a partner at Scott Legal and have many years of experience processing EB-2 and EB-3, PERM cases under company sponsorship. If you have any questions during the presentation, please send them in the chat box or Q&A box, and we will save those for the end of the presentation. So now we will get started. All right, so we have a list here, how do you obtain an employment-based green card in the US? And we won't go over all of these categories since the focus today will be on EB-2 and EB-3, specifically company sponsorship. But just to mention a couple of the categories here, EB-1A is for individuals of extraordinary ability who've risen to the very top of their field. EB-1B is for outstanding researchers and professors, often coming to the US to pursue tenure track positions. EB-1C, for kind of these multinational managers or executives, maybe they're on an L visa and transitioning, to that green card based on an EB-1C. Under EB-2, this is for individuals who have an advanced degree, which would mean a U.S. master's degree or its equivalent, a bachelor's plus 5 years of progressive post-baccalaureate experience or higher. Or exceptional ability, which is a lower standard than extraordinary ability, and you show you meet 3 out of 7 criteria. Once you've met that threshold requirement, then there's 2 ways to get a green card under EB-2. We're going to focus on the PERM process today, but there's also a national interest waiver where you can ask the government to waive the normal PERM process. Because usually an applicant can prove they're working on an endeavor of substantial merit and national importance. They're well positioned to advance that endeavor, and thus they argue the government should waive this normal PERM, company sponsorship requirement. We do have separate presentations that go over some of these categories in more detail if you have an interest in them. EB-3, so we'll talk more about this later in the presentation, but this is for professionals. That's where the job requires at least a U.S. bachelor's degree. Skilled labor, which is, 2 years of experience, education, training, or more. And then unskilled workers, which is anything under 2 years of experience. And there's kind of less green cards available in that category. Then there's also EB-4 and EB-5. EB-5 is for investment and creation of U.S. jobs. We also have a separate presentation that goes over EB-5 if you have an interest in that. All right, let's talk a little bit more about the PERM, the EB-2 and EB-3 categories, and what is the labor certification process, also called the PERM. So this is the process whereby most U.S. companies will sponsor a worker for a green card, meaning that the worker can stay in the United States permanently, and can work, for the company. It's no longer kind of tied to a specific role or a specific job as you may be on an H-1B or an L or a TN. So companies who really want to employ somebody long term, this is a process that they can take to do that. So it is a 3-step process. The first is the PERM, and then the I-140, and then the I-485 or consular processing, which is the actual green card. So let's talk about the PERM process first. So the first thing you're going to do is the company would need to come up with a PERM compliant job description. And when you're testing the labor market for the PERM, rather than look for kind of your ideal candidate, you have to submit a job description that asks for the minimum requirements to do the job in a reasonable manner. So it is something where normally a job description is going to say, everything you want, master's preferred, excellent communicator. Those types of requirements have to be adjusted for the PERM process to ensure that the company is saying, if we had to hire somebody kind of off the street tomorrow for this job, what are the minimum qualifications they would need to do this job in a reasonable manner. So once you've drafted that job description and made sure that the employee themselves meets that, has that level of experience and education, and ideally had that before they joined the company, then you can go ahead and file for a prevailing wage determination. So this is a form that is filed with the Department of Labor, and it says, here is the job, here's the location of the job, here's what we think the job occupation code should be. And then the Department of Labor will review it and make their own assessment. And then, they will issue a prevailing wage determination. And that's going to say, here's what the occupation code is, and here's the prevailing wage. And the prevailing wage means that's the minimum that the employer can pay the employee, at the time that the green card is granted in the future. Important to keep in mind that based on current processing times and green card backlog, sometimes it can even be a period of a year to 2 years before the company would have to pay that wage. So, if the company says, well, the employee is not making this right now, but in maybe 2 to 3 years, it would be reasonable that they did, often you can still proceed. Once the prevailing wage is in place, then you can actually start the recruitment process, also called the labor market test. This is where the company will actually have to place advertisements. So this is something where the company will place at least 3 advertisements, and then if it's a professional position or above, then they have to place 6 advertisements, and this is all regulated, kind of by what's in the regulation. So they can't just place the ads anywhere they want. They have to be placed in, for example, the state workforce agency in the state where the job is located. A notice of filing has to be placed at the physical work site. You also have to place 2 ads in the newspaper of general circulation. And then there's kind of a list that you can choose from for those people that have to do an additional 3 ads. So once you get through this process, usually it's a process that's at least 60 days because some of the ads have to be placed for at least 30 days. And then you need at least 30 days after they're placed, to kind of continue the recruitment process. If the company has not found any willing, qualified, and available U.S. workers at that time, then they can proceed and actually file the labor certification with the Department of Labor. Right now, that's where they basically say we conducted, the labor market test. We put the job description out there. We did not find any willing, qualified, and available U.S. workers for the job. Very common question: Do you have to hire somebody if you find a qualified worker? And no, the company does not have to hire anybody if they find them during recruitment. That being said, it does mean that they cannot proceed with the labor certification at that point in time because there are, willing, qualified, and available U.S. workers for the job. So the government does not want to allow the company to sponsor this worker. If that does happen and the company still wants to try employing this person, they could always wait some period of time and try again and test the labor market at a later time. If you can move ahead, then once you file the labor certification, you are waiting. Right now, wait times are quite long, somewhere between kind of 14 to 16 months. And what you can get is an approval, also meaning the labor certification is certified. You can also be denied, or you can receive an audit. And an audit is where they will ask for all the proof that you conducted the labor market test in the correct way. So they'll ask for resumes of people that applied, evaluation sheets, proving why the person was not qualified, proof that the company conducted the recruitment in good faith and contacted applicants quickly. There are certain audit triggers. So sometimes, if a job requires a foreign language, but the job is not something like a Spanish teacher, they may audit you for that. Also for requirements normally outside the occupation. So they have an idea of what is reasonable and a reasonable amount of education and experience. If the job requires more than that, the company may be required to justify that based on business necessity. So all these filings are with the Department of Labor and not with U.S. Citizenship and Immigration Services. Um, and that's kind of the whole thing for this first part of the perm. Timing is quite long, so drafting the job description sometimes can take a bit of time with the back and forth. Although that part can go faster depending on the employer. The prevailing wage is taking about 6 to 8 months. The recruitment process takes at least 2 months. And then the actual wait time to get the labor certification is 14 to 16 months. So you are looking at a process of up to 2 years for just this first step. Once you get past this first step, then you can go ahead and file the I-140 petition. So this is the one piece that you can actually premium process right now. This is where the company is going to say, we want to sponsor this person, and the employee will also submit the proof that they meet all the qualifications of the job and that they met the qualifications of the job before they joined the company. So this is, the company will also have to prove that they have the ability to pay that prevailing wage and did have that ability from the time they filed the perm. So you do want to be looking at those financials. Companies that have over 100 employees can sometimes submit a letter from their CFO in lieu of tax returns or audited financial statements. Otherwise, generally you will have to submit those tax returns or annual reports. The last step of the process is the green card step. So this can be done through an I-485 or consular processing. We say here, timing, is it current or not? What this means is there are a certain number of employment-based green cards that can be issued in any given year. And when those categories, when more green cards than that are issued, then the categories become backlogged. There are worldwide backlogs right now. So everybody, the category is not current for EB-2 and EB-3. And then there's kind of longer backlogs even for people who were born in China or India. So very important to consider, is your priority date current? And if it's not, if there's going to be some wait period, and you want to stay in the US, do you have an interim status that you can stay in? Your family members can also join your green card application. That includes your spouse and any unmarried children under 21. All right, let's talk a little bit more about the green card process and the differences between adjustment of status and consular processing. So with adjustment of status, this is generally used by people who are living and working in the United States where their families are here. This involves filing a Form I-485 with U.S. Citizenship and Immigration Services. Benefits are an ability to remain in the U.S. while the I-485 is pending. You also can file for work and travel authorization. And at the end of the process, most applicants will have an interview with the USCIS officer. We'll talk a little bit more about that later. It is possible that the case is approved without interview, but generally, as happened in the past Trump administration, as we've seen now, we do see kind of less interview waivers and more people being interviewed. Consular processing, this is more for people who either are outside the United States, maybe their visa status, ran out and they couldn't get a new one, or maybe they're on a status like an E-2 and they need to travel and can't wait, a year for the travel authorization to come through. So they need to be able to travel. This is where your approval, your I-140 approval, is going to be sent to the National Visa Center. Then you fill out a DS-160, you provide kind of supporting documents, your birth certificate, similar things that you would apply or supply for the I-485. The National Visa Center will review all your documents. Once they determine that all the documents are there, they will send the file to the U.S. consulate to actually schedule your visa interview. You will then attend an interview at the consulate. You'll have to do a medical exam prior. If you are approved, they'll put an immigrant visa in your passport. That's valid for 6 months. You have to enter while that's still valid. And then you'll be entered into legal permanent resident status, and your green card will be mailed to you after you enter the United States. All right, a very common question, who can pay for the green card fees? And there are some very specific rules around this because the government does not want to incentivize employees just paying their employers to sponsor them. So any fees that are related to the PERM process, legal fees and other fees such as, paying for the advertisements during a labor market test, all of those have to be paid by the sponsoring employer. They cannot be paid by the employee. When you get to the stage of the I-140 and the green card applications and the applications for dependents, those can be paid either by the employer or employee. All right, let's talk a little bit about dual intent. So there are many non-immigrant visas that don't allow for dual intent. So this means when you apply for them, you have to, legitimately convince the immigration officer that you do not intend to move to the United States permanently. So if you're applying, for example, for a B tourist visa or an F1 student visa, you cannot have the intent to immigrate permanently. You have to show you have a residence abroad you don't intend to abandon. There are some visas that do allow for dual intent. The most permissive ones are the H-1B and the L. If you are on an H-1B or an L visa, there's specific language in the regulations that says it is okay for you to have the intent to immigrate permanently, even even while you're on this temporary visa. So those are kind of the, if you're going through the green card process, the easiest visas to be on will be the H-1B or the L. The O is also listed here just because there is some kind of language, in the Foreign Affairs Manual and the regulations that does suggest that O's are also treated almost as quasi-dual intent visas. So it's not as strong of an argument as it is with the H-1B and the L. You don't get the same permission the H-1B and the L visa applicants get to kind of travel during the green card process. However, if you are in the green card process and you are on an O, there are some arguments you can use to, say that it's not inconsistent that you still intend to get a green card in the future. All right, so timing and underlying visa status. So when you're moving from a temporary visa to a green card and you're using the PERM process, you really want to be planning ahead because, as I mentioned, the timelines are quite long right now. You want to consider how much time is left on your underlying visa. For example, if you are on a TN visa, it can be very difficult to extend, that visa or get a new approval for that visa once you have an I-140 filed because the TN has a very high standard for non-immigrant intent. And if you filed a petition and say, well, I do intend to be in the US permanently, it can be hard to convince them that, well, on this entry, I don't have permanent intent, so I should be granted this visa. That's to say that you do, maybe if there's an option to switch to an H-1B, or another type of visa, you may consider that, or you may just consider, timing it so that, at the time that the green card, I-140 filing is happening, maybe your TN has been renewed and you have a few years left, so you're not worried about that issue. You also want to consider, do you want to adjust your status or get the green card through consular processing? So thinking about what are the timelines for travel authorization? Do I have an H-1B or an L that will allow me to travel? Do I have a valid visa stamp for that? So all of that is very important to figure out. Um, you know, if you want to go through consular processing because you're on an E and you have to travel constantly, you want to consider that and just think about, on your I-140, making sure it's clear you're pursuing consular processing so you don't have issues, when you're trying to enter the US. Also want to think about your family. So do you have children that need the green card? Your children will eventually age out of eligibility, so if you do have a child that's kind of 18, 19, you really want to be thinking about this because it can take a few years to get to the green card stage and they might age out. All right. So I mentioned previously that you will likely have an interview if you are doing an adjustment of status. If you are doing consular processing for the green card, you will definitely have an interview. And here's how to prepare for that. So you should review your immigrant visa petition and your green card petition before the interview. You want to make sure that the answers that you're giving are consistent, that the officer feels that you're credible, that when they ask what is the job, what is the job description and the job duties, that those are all aligned with what's in your application. You want to organize and print documents to bring to the interview. So bring those originals with you, original birth and marriage certificates, things like that, and then bring copies as well. They should have a copy in their files, but it's always better to have that, and be prepared. You want to ensure that your medical exam is completed. So if you're doing that in the United States, that's going to be on Form I-693. You have to go to a specific type of doctor that USCIS has approved for this. Get this in advance. Um, you know, Now it used to be that you could bring this to the interview. Now they require it when you file the adjustment of status. So it should be that this is already completed. But if for some reason you're in that period of time where you hadn't provided it yet because it wasn't required at the time you filed a few years ago, make sure that you have that with you if you haven't submitted it. If you're going to the consulate, you'll have to get a medical exam done with a panel physician, and they have specific ones authorized in each country. So you will not be able to do it in the US or another country. You have to do it kind of where you're having your immigrant visa interview. Get updated proof of employment from your sponsoring employer. So a good idea to kind of bring an updated letter that just confirms they are still offering you this job under the terms as outlined in the PERM, or if you've ported, which we'll talk about a little bit later. That you have the proof of that as well. Also, proof of maintenance of status. So if you are doing an adjustment of status, you have to prove that you have maintained your status. If there's been any kind of periods of time out of status, even small ones or inadvertent ones, this can be a bar to adjustment, but you can utilize a provision called 245K, which kind of forgives, those issues as long as you have not violated your status or worked without employment for up to 180 days after your most recent entry to the US. So if you've been in the US for a very, very long time and never left, again, definitely an important thing to discuss with your attorney. And in any event, always important to discuss your entire immigration history in the US with your attorney ahead of time. Meet with your attorney and do a practice interview. Even if you feel like you know the answers and you don't need to practice, it's a good idea to do so. You may be nervous on the day of, and so always a good idea just to think, you don't need to memorize answers, but just how would I answer these questions? All right, what is porting? So a very common question we get during the process, especially because it's so long, is, can this person be promoted, or, do they need to stay, in the same exact job? And for a lot of the perm process, it's very difficult to change things. Or if you change employers during the process, or you leave, your employer, you often don't take much with you. Like if someone has started a perm for you but not filed it, and you go to a new employer, you don't really take any benefit from that green card process that was started. You have to start all over with the new employer. So what porting does is it allows employees to change employers um, only after the I-485 has been pending for at least 180 days. So the I-140 still has to be approved, but assuming that it is, and the I-485 has been pending for at least 180 days, you can switch to a new job in the same or a similar occupational classification as that on the I-140 and in the PERM, uh, you know, eh, and that can be the new basis of your green card application. So you do have to, kind of gather the proof that these jobs are in the same or a similar occupational classification. And if you're switching to a new employer, get that information. But the benefit is that if you do switch to a new employer, they don't have to start all over. They don't have to file a new PERM. They don't have to file a new I-140. Whereas if you left, your employer when just an I-140 was filed, they would have to go through that PERM process again for you. Okay, changing employers after obtaining a green card. So people will, again, because it's a very long process, many, many years, people may want to move. They may ask, can I change employers after I get my green card? And the answer is yes. Once you do have your green card, that does permit you to work, anywhere in the United States, including for yourself. You are not required to just stay with your employer indefinitely. That being said, when you got your green card approved, you did represent to the government that you intended to work at this company indefinitely. So if that has changed for some reason, there should be some, explanation as to why. That's to say, it's not a good idea to kind of get your green card and quit your job the next day or the next week. Generally, you want to be working there for at least some period of months and then have some explanation for why you left, whether it's I got a better job, a better job offer, my spouse got a better job offer, we moved for our child, whatever it is, there should be an explanation, so the government feels comfortable that there was no misrepresentation when you went to the green card interview. The place this can normally come up is kind of at the naturalization interview. So when you submit your naturalization application to become a U.S. citizen, they'll look back at your work and, your work history, and may also look at the basis under which you got your green card. And if they feel there were any misrepresentations, that could be problematic. So you definitely want to avoid that. But the short answer is yes, you can change your employer after you get your green card. All right, so we've reached the end of the presentation and we have not had any questions come in, so we will close here. Thank you very much.